The first part of the evidentiary hearing was held yesterday in the Richland County Courthouse, where a juror's paid travel plans had interfered with the scheduled hearing to begin on Monday the 29th. Despite all of the conspiracy theories and Dick's attempts to accuse the state and SLED of prepping Becky, Justice Toll again brought sanity to the situation. Like a petulant child, Dick of course is still trying to break the rules, and Justice Toll is still shutting him down. We don't get to hear or view the questioning yet, as a means to keep the rest of the jury from having a chance to prepare or discuss what their answers will be on Monday. Let's get started. This is Legal Updates with Cassidy. A single juror testified, and Dick is still inappropriate. Welcome.
Welcome, ladies and gentlemen. This is the matter of State versus Richard Alexander Murdaugh.
After introducing the case, Justice Toll reminds us that Alex's appeal has been put on pause while this evidentiary hearing is held in this court.
This is an evidentiary hearing with respect to the defendant's motion for a new trial, which has been remanded to this court from the Court of Appeals where the matter is on appeal pause for the conduct of this hearing. I've got a couple of preliminary things.
Then she provides special instruction to the media and to counsel, since this case is very unique.
Members of the press, as I explained earlier, this procedure is unique in that typically issues like this are raised immediately after the rendering of a verdict. And we are now almost a year post-verdict in this matter, which makes this a very unusual situation for you and for me to preside over. The defense has asked the jurors be sequestered prior to giving testimony for this motion. To accommodate that request and to accommodate an unavoidable schedule conflict for one juror, that juror is being examined today. The remaining jurors will be examined Monday. Under South Carolina law, particularly State versus Sinclair, the examination today could take place outside of it and a transcript released at a later time. As a compromise, I am examining one juror today. I have previously had an off-the-record consultation with members of the press, and I'm now going to put on the record what I have discussed. I have asked that the gender of the juror, the questions asked, and the juror's response not be reported until after this court convenes on Monday at 9:30 a.m. for the examination of the balance of the jurors and the clerk of court. The press term is embargo, I think, but what I am asking is that these questions and answers and the gender of the juror be embargoed until 9:30 on Monday. I deeply appreciate the cooperation of the media about this. The behavior has been exemplary throughout. I am very pleased and grateful for the participation of Jay Bender as the media coordinator for this matter. Completely voluntary and without pay. And Jay, we really appreciate your assistance, and I know the members of the media do. And again, thank you so much for your cooperation with this request.
In my last podcast, we talked about how Dick Harpootlian had objected to the questions that Justice Toll had chosen for this hearing. We see her once again standing her ground. She will follow the most recent ruling on a case like this, which is State versus Green.
Now, I have had many communications with both the state and the defense about how to conduct this examination. I have given the state and the defense the questions which I intend to propound to the juror. And as I have explained in my communications, they are loosely based on the examination conducted in State versus Green, which is the last major pronouncement by the South Carolina Supreme Court in 2021 about how issues regarding the possible taint of the jury by some communication from someone not a juror is to be handled. And I have tried to model this procedure on that, although it's very difficult for both parties in this case because of the length of time that has taken place since the verdict was rendered. I have received objections to questions that I'm going to propound by both the state and by the defense. Mr. Harpoon, I particularly appreciate your quick response yesterday to the inquiry I made about these questions, and I have taken the comments of Mr. Waters and Mr. Harpoon into account, and I have slightly revised my questions, and I would like Ms. Diaz for you at this time to go to both sides and pass out the copies of the questions as I propose to propound them.
So Creighton has responded to Justice Toll's email, but as of now has still not filed it on the website, so I don't have access to it. But Justice Toll has taken into consideration things that both state and defense have said to her in their responses, so she has changed her questions just a little bit.
Counsel, if you will take a moment, we'll just be at ease. If you can take a moment to examine these questions.
And of course, Dick has to speak up because he just cannot wait to get his hands on Becky Hill.
Yes, sir.
Your Honor, I have one other matter I'd like to put on the record.
Yes, sir.
Your Honor, I move for continuance in my state grounds.
Yes, of course.
Your Honor, what we're determining is this. These jurors over the next, today and on Monday will be asked, did Ms. Hill say anything? I mean, the way you're going to ask it. If so, what did she say? And it's unclear as to whether or not you are going to allow us, well, A, that she's going to be required to testify, and B, if so, will you examine her or we examine her?
You're talking about the
Ms. Hill.
court?
Yes, ma'am.
Thank you for asking that question. I had intended to go over how we're going to operate on Monday after this examination was complete, and we'll do that. But let me just tell you, I certainly anticipate that the state will put this witness up and you will cross-examine this witness. Because there's some uncertainty about what the testimony will be, I will be flexible with the state about how they examine this witness, and I will be flexible with you about how you examine this witness. I reserve the option of asking questions myself at the end if there are things I think have not been covered that need to be covered. But each side will be able to examine on the clerk's court.
So with the jurors, they will be questioned exclusively by Justice Toll. But when it comes to Becky Hill, Justice Toll is going to allow both the state and the defense to question her, reserving her own questions for the end.
Your Honor, to that end, and that's one of the reasons.
And I've said certain things before about the parameters of what I think needs to be considered in this matter. And I'm not going to go back over all that at the moment, but there may be some limitations on what can be asked, Ms. Hill, because I don't think these questions are aimed at two things, showing, well, the question aimed at showing what, if anything, the clerk of court said to these jurors might bear on the merits of the matter before they render their verdict. But in addition to that, there are certain questions that are going to be asked that you say goes to the credibility of the witness. I think I am able to fully examine the credibility of the witness without going through everything that has entangled her since the close of this case.
Justice Toll knows exactly where Dick is heading with this questioning, and she expertly cuts him off, reminding him that she has already ruled that she is not going to go through every little piece of evidence that he has against Becky, that this hearing is about two very specific things, and only those things.
And we've already talked about all that. Just let me finish.
I'm sorry.
And we can talk some more about that, but I'm not going to delay this examination and get into the details of the Hill examination. I have said that only the jurors who sat on this case and rendered the verdict are going to be examined. And I know there's some controversy about how deeply you want to get into questions that you think arise from interaction with the alternate who was dismissed.
I love how Justice Toll is like the mom who sees her son about to try a sneaky approach around the rules. She cuts him right off before he can even speak. She says, just let me finish. I'm not going to delay this examination to get into the details of the Hill examination, because today is just about the one juror. But he is so fixed on getting around what she has ruled on when it comes to Becky Hill that he just can't shut up and let the day's hearing proceed. Again, she says, I have said. It's been ruled on, Dick. She knows you object. You objected at the status conference. You objected in your letter. She knows you object. Now sit down and let the day's stuff take place. Then she says, I have said. In other words, it's done. Stop. That only the jurors who sat on this case and rendered the verdict are going to be examined. Puts up another stop sign. I know there's some controversy about how deeply you want to get into questions that you think arise in the alternate who was dismissed. That egg lady, that troublesome egg lady.
I take the position that she was dismissed for things that had nothing to do with this Facebook debacle that took place, and Judge Newman made that ruling, and I am following absolutely exactly what the trial judge ruled.
She said that Facebook debacle. It took me a while to stop laughing after I heard that, and I am so pleased. My crew knows that I have wanted that stupid Facebook thing ruled out since it was very first introduced. It's so nonsensical. They have zero proof to tie it to Becky. You cannot keep throwing that in the court's face without proof to tie it to her, which as of yet they have been unable to do. Not only that, as she just said, this juror's removal had nothing to do with that Facebook debacle. So it is not relevant at all. You guys know how long I've been waiting to hear a judge say that. She reminds him that Judge Newman ruled on this and says she will uphold his decision.
We can talk about that some more later, but I don't intend to right now get into the details. So you will know, yes, you will be able to examine this the clerk of court.
But Your Honor, just two minor matters. We would not call any juror about why they were dismissed. That's not what the purpose would be.
I understand the purpose, and you were very eloquent about that, both in your written communications and in what you've argued when we were together last. I understand what your position is about that, and I think you understand mine. But we can talk about that further later.
Okay.
Still, he doesn't give up on having this egg juror on this hearing. Well, we won't talk about why anyone was dismissed. You're not getting it, Dick. She cuts him off again. Oh, you were very eloquent about that in your letter. She knows what he's trying to do, and she's not having it. I don't know how she resists the urge to say shut up and sit down. Instead, she says, I know your position, and I think you know mine.
Just one other matter, and that is we've recently been furnished by the state. First of all, we understand the state spent 6 hours with Ms. Hill preparing
I think that would be normal in my state to spend time with someone you've seen the doctor as a witness.
And they've also...
So here he comes trying to tattle, and now suddenly the 4 hours has become 6 hours. Oh, well, they spent 6 hours together with, and she cuts him right off. I understand that. And that would be normal. Just like I said yesterday. It is very, very normal for prosecution to meet with their witnesses, just like defense can meet with their witnesses. She's stopping him right there. So he may get the public outrage, get them talking, but legally speaking, this is normal. He's counting on people who don't understand that to spread this like wildfire. But you have to remember, these things must follow what's legally allowed. And Justice Toll knows what's legally allowed. And she knows that this is normal procedure. So for everyone who got all worked up by Dick's little trick, please understand, it was nothing more than a trick of a desperate defense.
Furnished to us the affidavit for a search warrant, which would indicate that Ms. Hill was somehow involved in the wiretapping by her son.
I am not going to get into that. That is a matter under investigation by the authorities. That is not something I'm going to get into. That's a very kind of thing we've already talked about at some length. I am trying to be very cautious, not out of any protection of the clerk of court, but I believe I can make a decision that need to be made in this case without touching on matters that are the subject of some sort of other official investigation, and I'm trying to stay away from that.
As Dick loves to brag, I've been doing this for over 50 years. He knows this stuff is inadmissible. He knows the judge is not going to allow this stuff. But he also knows that he's on TV. He also knows how many people are going to see this. So he brings up stuff that he knows is irrelevant to today's hearing, just to outrage the public. So he brings up this wiretapping situation. She reminds him that's part of an undergoing investigation, and I'm not going to get into it while Becky Hill is not represented in this court. He is trying so hard to make this a criminal proceeding against Becky. She will have her day in court. I keep saying this. It's for another court and another time. She is being investigated for these things, but that's not what today's hearing is about. You can't grab everything a person has done in their life and bring it in one hearing, especially if it has nothing to do with that hearing. People confuse and think that I'm defending Becky Hill. I am not defending her. If she did wrongdoing, I want to see her prosecuted as well. It's not about that. It's about what's relevant to this hearing and only what's relevant to this hearing. This stuff, not relevant.
Under Rule 614B, we believe we should be able to have a full and thorough cross-examination of this
I know,
witness.
but Mr. Harwood, two things. You're talking about a motion to continue right now.
Yes, ma'am.
I don't need to get into a full examination of all your arguments about clerk of court Hill right now. I'm not going to do that.
Well, we can't be prepared to cross-examine her without additional time. We're just getting information from the state this week.
Well, I deny the motion to continue. Respectfully.
Yes, Your Honor. Thank you.
So he tries again to get a motion to continue, another stall tactic, because he claims to be still getting new information in. But again, that information is a completely different investigation and has nothing to do with the verdict. The only issues at stake are what Becky Hill may or may not have said to the jury and whether or not it influenced them. So all of this is just to shine a light on this bad, bad woman, and she's not having it. As I said yesterday, the jurors are the evidence, and the jurors are the only evidence.
All right, Mr. Waters.
Nothing from the state, Your Honor.
Subject to all previous objections already lodged, Mr. Harwood.
No, Your Honor, not as to this juror. I would like to discuss with the courts the logistics for next week.
Sure, we'll have a full discussion of the logistics for Monday as soon as we dismiss the juror.
We're done with the juror.
Thank you, sir.
Subject to our previously made objections.
Very good. Mr. Bland, you may go to your client now and notify her, number one, she's free to leave. Number two, please honor the instructions that I've given with respect to discussing this matter with other jurors. Thank you so much.
So out of the need to sequester the other jurors, the questioning was done off camera. This is so the jurors who have not yet testified will not hear and know the questions they're to be asked by the court, and therefore cannot discuss or prepare their answers with each other or anyone else. It's also of note that Dick's request not to have Eric Bland there with his clients was not granted, as we clearly hear Justice Toll instructing him to go and inform his client that they are free to leave the court. It's ridiculous that Dick thought that he should be able to strip these jurors of their right to be escorted and otherwise protected by their attorneys. They must feel pretty anxious having their verdict questioned before the world. And what a burden for them to have to travel all the way to Columbia just to state that they followed the court's instructions and made an informed and correct verdict based solely on evidence at the trial. I support the jurors here.
All right, let's talk about what happens on Monday. My scenario about this is that, of course, the jurors will all be escorted securely to the jury room. I do not propose to have their lawyers with them in the jury room. I do propose to have a bailiff in there. I think there's kind of comfort in numbers, so I don't think they need an individual escort into the jury room. But the bailiff will be with them. I will call them one by one. I will try to come up with some X's, Y's, and Z's to enumerate, and I ask that when we deal with questions for them, that whatever the key is I've developed will be the one you use for these jurors, and I'll get that to you sometime today, I hope.
Now she moves on to instructions about what's going to happen on Monday when the remaining jurors are questioned. She does say at that time that no attorneys will be allowed in the jury room with the jurors, but they will be taken care of by a bailiff as is normal court procedure. She also mentions that she's going to come up with a way to refer to them instead of their previous juror numbers. Too bad Dick already ruined one of those.
I would bring the jurors to the jury box and give them instructions as I gave and remarks as I gave to this juror today. I will then send them to the jury room, and one by one I will call them to examine. When the juror is examined, the juror will then be seated in the jury box, and I will go through the numbers until we examine all the jurors. Then I will receive, of course, any further information that is needed from y'all, and then the jurors will be dismissed or allowed to remain in the jury box with the testimony of the clerk of court at their desire.
So her plan will be to question the jurors one by one. When they're being questioned, they will be sat in the witness seat. When they've finished being questioned by Justice Toll, they will take a seat in the jury box. They'll remain there throughout the questioning of the other jurors, at which point she'll then receive any additional information needed by the attorneys, and we can imagine Dick will have something smart to say at that time. Mark my word, especially if things don't go his way, and then they may choose to remain in the jury box for the questioning of Becky Hill, or they may be dismissed as they choose.
Then the clerk of court would be offered, and I would propose that she'd be directly examined by the state, but I, again, say to the state, I will be very flexible about how that examination is done because of the circumstances in which we find ourselves. And I will do the same for the defense and allow free cross-examination. But I will be very sensitive about not straying into areas that simply are further indication of what defense contends is her lack of credibility and her motive for doing whatever it is they say she did. I think I am able to evaluate both of those things and make a determination from that, that is motive testimony and testimony as to what exactly was said and done without exploring the full breadth of matters that may be under examination by other parties. I want to get into that and inadvertently start a proceeding here that would interfere with any other investigation that is being made in connection with this matter.
She reiterates once again how the process will go. Becky Hill will first be questioned by the state and then cross-examined by the defense. She has to make it clear once again that anything outside of the scope of exactly what's under question at the moment, she is not going to allow to happen. And she makes it very clear why at the end. She doesn't want anything to interfere with an ongoing investigation, and that's something that must be respected. Becky is under investigation at this time, so having her speak on the accusations that are currently up against her could affect that investigation. So following legal requirements, that investigation is not to be a part of this hearing.
So I'm sensitive about that. And I'll try to do the very best I can. That's all I can do, of course. And you, of course, are going to be free to lies whatever disagreement with the way I proceed, you would care to, and have it fully preserved on the record. I have great comfort of knowing that I am simply a trial judge in this matter, and others will evaluate these matters on appeal as it should be. I have not found another case in South Carolina's jurisprudence that is exactly like this, so there's plenty of room for guidance in the court, both Court of Appeals and Supreme Court, if they choose to do that. And I am very comfortable with that, and anything you wish to put in the record that would aid in your position about these matters. All right, that said, what things am I not covering, Mr. Waters, that you want covered about the procedure from the state's point of view?
She very humbly acknowledges that this case is not like any other case, and recognizes that this will go to appeals later. And that's why we see a lot of these objections by Dick and comments by Dick. It's a matter of getting it put on record for an appeal later. So it's just a reminder to us of how many years we still have ahead of us with this case as he proceeds to exhaust all appeals in the future.
I believe we understand, Your Honor, and everything that you've indicated is acceptable to us. Obviously, we've made arrangements to get the jurors here and brought in a secure fashion, and obviously we're certainly comfortable with them being in a room together. If there's a bail up there, instructing them, of course, not to talk about the merits of anything for this proceeding. And we certainly understand your court's ruling as to the examination of the clerk. We'll be prepared to proceed, and obviously, as we develop, make whatever objections we think are appropriate. But we're comfortable with the court's proceeding.
Thank you, sir. Mr. Harper, please.
Your Honor, who is transporting the jurors here?
Sir?
Who's transporting the jurors here?
Sled, I think, or
Your Honor, we obviously gave the jurors that option. I believe that there may be one that is getting a ride, but other than that, the jurors are transporting themselves. However, just like we did at trial, they will meet at an undisclosed location off-site, and then SLED will escort them in through a secure entrance so that they...
Yes, that is what I had understood, Mr. Harpootlian, is that the state has provided a gathering point for them that is at a distance from having to put up with the traffic and the confusion of the courthouse. And they will then be brought to the courthouse and placed in, and come through the secure entrance and be placed in the jury assembly room. That's how it began.
And of course, Dick has to object to SLED. Dick, the same guy who went to these people's homes, criticized the roads they lived on, told them that other jurors have said blah 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 in very leading questions, and documented affidavits outside of the court's presence. This inappropriate man now has to express his concerns of just how dirty he thinks SLED is, that they might say something that these poor, weak-minded jurors who have no minds of their own, no ability to reason, no logic, and no intelligence, they're so easily corrupted in Dick's eyes, so he's got to object to them being escorted by the state police.
Your Honor, I just say this for the record, and it's going to be an objection I'm going to have to make over and over again. SLED was the original investigating agency. They were the prosecutors, and they continue to interview jurors. The same agency. There's no Chinese wall provision as we would do in private practice. There'd be a Chinese wall. There's no Chinese wall.
Chinese wall, Dick? Chinese wall? This is Dick's reputation of not keeping up with what is appropriate and inappropriate to say. Chinese wall used to be used as a legal term, being associated with the Great Wall of China. However, this term has been denounced as culturally insensitive, with one judge suggesting ethics wall, others using the term screen, firewall, or cone of silence, or the verb to screen, which is the term that the American Bar Association Model Rules of Professional Conduct has adapted. It reminds me of the time that he used the word midget, and when corrected, continued to use the word and laugh about it.
And it may actually be that Newt Gingrich is getting ready to surge 60 days out from the primary. So for us Democrats, this is, again, I compare this to midget mud wrestling. We don't know who's going to win, but when it's over, it's going to be a midget covered in mud.
By the way, you're not allowed to say midget anymore. It's little people.
You're not. What do you say?
But I'm sure the rest of the reference, it doesn't offend them either. Let me ask you this, but you had to say little people. Little people.
Well, Dick,
Vertically challenged.
Dick, in that little sentence that you made, you just knocked out another important voting group.
Brad,
The midget?
let me stop saying it. I'm going to get hate
Brad,
mail.
I don't think they can reach the machine.
Stop that. Brad, let me ask you this. There is one president who had a 48%. Brad.
The midget?
I'm going to get hate
Brad,
mail.
I don't think they can reach the machine.
Brad, let me ask you this. There is one president who had a... Brad, let me ask you this. There is...
Repulsive. After saying it multiple times, I don't know if someone kicked him under the table, shot him a look, or if it finally dawned on him, but it did finally get through to him that he shouldn't have said that.
I shouldn't even use that term anymore. I think they call it ethical barrier. Took a deposition in San Francisco not long ago and used that term and got my hat handed to me, if you will.
And rightly so.
So, but there's no such provision in apparently it's SLED, so it raises questions about the integrity, not of the state, but of the process, which should be avoided. That's number one. Number two, when we examine Ms. Hill, we understand we have a rendition of a statement that was taken, a sworn statement, and then notes from a subsequent. Are there notes from the interview this week?
There was a prep meeting, but even though that was a prep meeting with the attorneys, as I always have, will provide the defense with anything that I believe is an addition to that, which has already been provided. And so as we always do, we'll do that. We conducted this investigation with independence and integrity, and all the SLED agents have been instructed, Your Honor, that they are in no way to do anything but gather the facts, good, bad, or ugly. The SLED agents that will be transporting the jurors are instructed, strict instructions not at all to discuss the matter of the case. We've been very mindful and careful to ensure that there is no thumb on the scale in this inquiry, and we will continue to do so.
Too bad there's no one monitoring Dick's unethical behavior.
State for the record, I have no question about Mr. Waters' integrity, his intentions, not so much for the police officers. That's my experience, having stood in this courtroom many years as a prosecutor. Sometimes law enforcement officers become overzealous to protect the arrests they make, whether it be a motion to suppress or otherwise. I'm not saying the attorneys in this case in any way can put their thumb on the scales. I just, to the extent that you can Chinese wall, to the extent that you keep.
And here we go again with the Chinese wall. Here's some Chinese for you, Dick. 蠢人不会从自己的错误中学到教训，所以他还会继续犯错. Which means, in Mandarin, the foolish man never learns from his mistakes, so he continues making the same one over and over again.
Folks insulated, I think, is a good thing. The second thing is this. It took about 15 minutes to do this juror. So if we do 11 more jurors, it's going to take 2.5, 3 hours with breaks, I would think, which means we start at 9:30, probably break for lunch, and then come back and do Ms. Hill. It would be, does that sound reasonable?
Yes.
Okay. And we may attempt to call witnesses after Ms. Hill. Obviously, Your Honor, we'll have to decide at that juncture whether they are appropriate or not.
Did he forget that Justice Toll was very clear that all proffers should be in written form outside of the jurors that she chose to interview?
But we may want to make a brief proffer on the record of what they would say. I think we only have one.
Okay,
Not the
I'm going to give you
not
some
the
flexibility about that, Mr. Harpootman. I ruled out having testimonial proffer in this case and told you I wanted it submitted in written form or otherwise. If you choose to put it on the record in verbal form, I won't prevent that. But I'm not going to take up a big block of time taking all kinds of testimony.
He is not going to give this up, and I hope she stands her ground.
The problem is the when we've submitted written affidavits, won't accommodate, like the things we heard this morning. I mean, things come up in Ms. Hill's testimony or other jurors' testimony that may be relevant. I mean, the person we have is given an affidavit. It is not the so-called egg lady, okay?
Well, I understand that, and I'm not going to make you recite what you plan until the opportunity presents itself after the testimony of Hill was taken. So know that I would permit some kind of on-the-record proffer. I just don't want to go through a whole bunch of actual testimony in connection.
And that pretty much sums up this hearing. She does go on to say that she thinks that they can finish this all up on Monday, even though they've slotted 3 full days to handle this matter. I know we'll all be watching this hearing on Monday, and I'll get my commentary on it to you as soon as possible. Till then, this is Cassidy O'Connell saying stay well and stay tuned.